Welcome to the March to a Million podcast with Greg DuPont, founder of the Wealth Solutions Network. In this podcast, Greg shares his journey to positively impact 1 million lives by creating an army of financially minded attorneys who embrace an expanded role in their clients' lives. Greg and his guests challenge the status quo in the legal profession and the financial services industry, and show attorneys how they can improve their lives, provide greater value to their clients, and experience greater professional satisfaction. Join us in this movement and strengthen your business by learning how to solve your clients' most pressing financial problems.
Hello and welcome to another March to a Million podcast with your host, Greg DuPont. Now, today we have David Foster, Director of Advanced Planning for Simplicity. He focuses on wealth transfer, business succession planning, charitable planning, and executive compensation planning. We are in for a lot of information here. Greg, take it away.
Thank you, Matt. David, thanks for taking the time to join me on the podcast here today and volunteering to share your wealth of knowledge. You know, what I wanted the listeners to understand is, part of what I have experienced in my journeys from just practicing law, estate planning, to now integrating financial services holistically like we do at Wealth Solutions Network is just what a gap there has been in my own knowledge base as to some of the tools that are out there for us to improve the lives of our business owners. And I've spoken with David recently with regard to some cases that we're working on, and I think it'd be very helpful for you to kind of make some notes here today as we talk about some of the tools that are out there for your clients that are business owners that are looking to preserve, protect, and transfer the wealth. So, Dave, if you could, again, thanks for joining us. Would you just briefly tell people kind of what your role is as the advanced planning specialist for Simplicity Group?
Oh, absolutely. And it's been my pleasure. Thanks for inviting me. Basically, what I do is support advisors on the little bit more complex tax and legal aspects of high net worth individuals and business owners. I would categorize them that way. On the business owner side, that's more along the lines of succession planning, buy-sell agreements, executive compensation, some of the different unique aspects of financial products as they relate to business owners and how they may use them, the different ways that entrepreneurs think, small business owners think, et cetera, and how some of the risk management products that we have fit into their world. But it can get complex. There are some unique aspects to the tax and legal side of those things. Not every attorney, CPA, financial advisor deals with them on a daily basis, so that's where I come in.
And specifically, you and I have been kind of working together on a couple cases lately, and in the buy-sell arena. And that was one of the things that we really wanted to talk about during our conversation today. Is some recent developments, the Conley case, and kind of that underscores some of the concerns that we as true fiduciaries dealing with our business owners really need to understand what's going on out there from a tax perspective, and specifically with the Conley case. So, David, you're the expert on that. Can you kind of unpeel that onion a little bit on what happened there and the implications of Conley?
Sure, I'll do my best. So I'll start off by saying this though. The end of the story on Conley is that pretty much every business, certainly the higher net worth ones, should review their buy-sell agreements. That's the end story is going to be that, and I'll get to that in a second. But to be quite honest with you, that's not different than what it was before. I've been preaching from the pulpit for the past few decades to let all advisors know, and business owners specifically, that they need to be reviewing their buy-sell agreements. Too many things change. They might have added a shareholder, tax laws might change, valuation might change, et cetera. So it's no different than anything else. They should have been reviewing these things at least on an every 3-year basis to begin with. But specifically, this Conley case, this comes from a Supreme Court case that was decided earlier this year. It's been going on since 2021. And it's actually an estate tax valuation case that came from the tax courts. The idea being that if you have a stock redemption buy-sell agreement, meaning that upon the death of a shareholder, the business itself, the entity, the corporation, will redeem the shares of the deceased shareholder. So that's a stock redemption buy-sell agreement, also sometimes called an entity purchase, but let's just focus on the corporation. And if it's a stock redemption, somebody passes away, a shareholder passes away, the entity, the corporation will redeem the shares. So how you fund that with life insurance oftentimes is you have the corporation own a life insurance policy. So let's just take the example of a $10 million business. Business is worth $10 million, and let's say you have two individuals that own it equally 50% each, and they both go out, and the corporation acquires $5 million of life insurance on each. In case any one of them were to pass away, the business would receive $5 million and would use that to redeem the shares of the deceased shareholder. Pretty simple. Buy-sell planning 101. The question has been around for a long time. What about the valuation of that business for estate tax purposes? You just added a death benefit. Does that increase the value of the entity for estate tax purposes? And technically speaking, the answer has always been yes, the valuation is increased by the death benefit received. But since the Blunt case a long time ago, which was in the 11th Circuit, the redemption agreement itself, this redemption obligation that the business had, acted to offset that increased value. So in my scenario, it went up $5 million because the insurance came into the business, but it went down $5 million because that business had to use that money to redeem the shares. Again, pretty simple. That's what the 11th Circuit said. 8th Circuit came along in the Conley case and said, no, we actually don't think that's the case. And there's a lot of technicalities, so I'm going to try to skip to the end story. So when you have two different circuits saying two different things, the Supreme Court came in. And the Supreme Court came in and agreed with the 8th Circuit and said, in this scenario, in the fact pattern at hand, which was the Conley case, the redemption, yes, the life insurance increased the value, but the redemption agreement did not decrease the value. So what you ended up with was an inflated value for estate tax purposes for the deceased shareholder's family. All right, so that's the negative side. The negative side is that, and that's what we're concerned about. So really, if you don't have an estate tax issue, a business that doesn't have an estate tax issue, this technically really doesn't apply to you, keeping in mind that the estate tax exemptions could get cut either in half in 2026 or way below that, depending on who wins the election. So that could be a lot of different business owners. There are ways that you could avoid that. It takes a well-drafted buy-sell agreement. It takes acting in the right way for that buy-sell agreement. It's not just the agreement itself. It's after that, how the parties act. But the general consensus is, number one, review your buy-sell agreements. Number two, you can always shift to something like a cross-purchase buy-sell agreement or an LLC agreement, something else, if that's an issue for your client. But it's without a doubt, all of these agreements should be reviewed, if that makes sense.
So to put some more color to that, so many of our clients have no buy-sell agreement whatsoever. Some passing language as to it in an operating agreement if we're lucky. But what you're pointing to, David, is how essential it is for attorney/advisor with business clients that have their own closely held businesses. Really needs to hone in on that concept of their buy sell and how it gets funded. Because what you just described there is number one, an outlier, right? In terms of the company actually had insurance to pay for the buyout, which is maybe 10% of small businesses, if that, right?
We see it a lot. I'd go above 10%, but yes, they're definitely out there.
Yeah. But so they bought themselves a bigger problem by the way that their buy-sell was structured, and the way that the insurance was put in, which comes from a lack of coordination from legal counsel and the insurance counsel in that situation.
Well, actually, in this particular case, they didn't do anything wrong. When they put those things in place, the 11th Circuit said that wasn't going to be a problem. Now it's a problem. So it's adjusting on the fly a little bit. So in this particular case, I wouldn't fault any of the advisors. But going forward from this day on, if they haven't taken care of it, I would fault the advisors.
So with that thought in mind, what would you suggest? Are there a couple 3 points that kind of bullet points that that our listeners may want to kind of make note of so that they can go and say to their clients, "Hey, we need to talk about A, B, and C."
I would absolutely. I mean, I'll say this first of all. I get a lot of advisors that approach me with what they say are the facts of a buy-sell agreement. They'll say, I have a business owner that here's their deal, here's the agreement, here's how it works. And I'll ask them if they actually have a copy of the buy-sell agreement. And they said, no, but this is what the business owner told me. So the first tip that I would give to anybody, never listen to what the business owner says the buy-sell agreement says. Always get a copy. And the impetus for doing that is there was a Supreme Court case, and Supreme being the key term there, it's not going to be appealed. There's nowhere else to appeal this. So this is the law of the land. If you have a business owner who has, and don't go by what the business owner says. You can't go to a business owner and say, do you have a stock redemption buy-sell agreement? They may say no, but they may actually have one. So you'd be saying to them as your advisor, I'd like to take a look at your buy-sell agreement to see if this Supreme Court case creates any tax traps, any tax problems for you. And that's what we're going to, use your attorney, use your legal advisor, counsel, et cetera, as well. But we're going to take a look at it. So A, get the document for sure. B, let them know that this is a tax issue on something that's new. This is not we're saying, hey, let's review it just in case. We're saying the laws just changed. I want to see if you have a problem. And I would say, if you've got a business that you got two owners and the whole company's worth $1 million, I wouldn't go with that line of reasoning. They're not going to have an estate tax issue. And this is, after all, it is a buy-sell issue, but it's also an estate tax issue, more importantly.
So not that we want to draw too many generalities out of it, but I think that is an important place to kind of draw a line because with an entity purchase agreement, that's, if we can get clients with a smaller business to at least take care of the funding problem that exists with a deceased member or partner, then we're getting some traction there. But what you're talking specifically about is, okay, if we've got under Conley, if we've got a few $1 million business that we're now compounding because we've now have an estate tax issue like we had in that case, then we need to be kind of looking at the funding mechanism differently. And
Yes.
maybe changing what we have done in the prior buy-sell agreement.
And the good news is there's a solution to almost anyone's particular issue. Like I said, changing to a cross-purchase, changing to an LLC cross-purchase token agreement. There's trust deed buy-sell agreements. There's a whole bunch of different solutions that you can provide them with. Some of them, especially those folks that think, I'm going to be retiring in the next 3 to 5 years and selling my business, so I don't care that much. Well, you might want to buy some additional term insurance coverage for the next 5 years or something like that, just to cover the potential for an estate tax issue you weren't expecting. So there's a whole bunch of solutions to this. They're not painted into a corner, but they do need to take a look at it.
So when we talk about kind of shifting gears, the type of services that you make available to our agents and people that are part of the family, let's talk a little bit about some of the more complex things that you come across that that are also things that you can help with. You mentioned a couple of them, charitable type of things and that type of stuff. So what would you say are like the top 5 kind of complex situations that you are approached about most frequently to get guidance on?
Well, these days, and the answer changes as the years go by, but right now, the biggest one is, what do I do with my exemption that I have, the estate tax exemption, considering the fact that it might get cut in half. And so, people are running out of time and they don't realize it. So the question becomes, I'm worth $40 million, $50 million, $100 million, a billion, whatever the number might be. I have an exemption right now of 13.61. That's $27.2 million for a married couple. What do I do with it? What's the most efficient way to do that? And I get a lot of, I've already utilized my exemption. I still want to transfer some wealth What's the most efficient way to do that? What are some other strategies that you can utilize? So I get a lot of that. And when you said complex wise, those are the more complex ones, because you're talking about transfers into a myriad of different types of trusts. It's just a word salad of different types of trust, all that do different things. And there's different strategies and ways to accomplish what they're trying to accomplish. And on top of that, you really have to focus on what the client's goals are. And I found a lot of advisors are focused a little bit more on the tax side and less on, well, what do we need to accomplish? What is their family? What are their family dynamics? What dynamics are we dealing with in a business that they might own? Things like that. So it gets a little bit complex when you're dealing with the trust side of things, because you're also dealing with state law on top of federal law, federal taxes on top of state taxes. There's solutions for all of it. There's nothing that we can't provide a solution for, but it really requires a heavy dose of fact finding and understanding of the client.
And I kind of want to jump back in on that a little bit, because that's what this network is all about. Is that being able, as an attorney that is now more aware of some of these tools out there, to also know that there are resources like David at your disposal, so you don't have to know all these things. You've got the expertise of David's years of dealing with these complex hybrid situations to help guide you through it, so that your clients are taken care of appropriately. And Dave, just kind of to put a bow on that, how many years have you been doing this type of stuff?
33 now.
And so the things that he has come upon, are the things that, when I'm doing a CE and I'm seeing them talk about things like David, I'm like, I'll never see that. But he sees those type of things regularly, because everything funnels into his office. And you just need to know that there are resources like this. So we just talked about kind of the complex end of things and the gazillionaires. Let's talk about the millionaire next door. What are the type of things that you have seen that may be kind of a gap that many insurance or financial advisors are not seeing the opportunity for their client to do some of these things? Is there kind of a pet peeve of yours of things that are missed, that people really need to be thinking about and taking advantage of?
Well, I'll say this, as far as if you jump to the other side from the very complex to the what I would call rather simple, I think a lot of times what we miss out on is the simple actually usually works really well. So the most common question I get from what I would refer to as the mass affluent, I mean, other than the typical, do I do a Roth IRA, conversion? Do I, what's Social Security? Those kind of things, which I don't actually deal with that often. We have another team of people that deal with that. I get this, I'm a successful business owner and I don't want to pay taxes. I mean, it's the simplest of all things. Now we do risk management, life annuity, long-term care, disability, those kinds of things are our focal points, basic, some financial planning, et cetera. But they come to us with a basic question. I'm more profitable than maybe I expected. I'm doing really well as a business owner. And wow, I didn't know I'd be getting hit with this much in taxes. And so the advisors are looking for something that does everything, right? They want to go back with some magic pill that says, I can show you how to avoid taxes. And I've been doing this long enough to know that I know exactly how the conversation is going to go. And I know that we're going to start with some kind of a hybrid qualified plan. I know we're going to start talking about 412E3 plan or a cash balance plan, a split funded plan, something like that. And if they have too many employees, it's not going to work. Mathematically, it just won't work. And then I know we're going to take the next step. And then I know somewhere along the line, an advisor is going to propose something rather aggressive that they shouldn't be doing. Going back to the 1990s, you had 419 AF6 plans, and you've had springing cash value plans. So if I had a pet peeve, it would be the aggressive plans that break the spirit of the law and then eventually actually break the law once the IRS catches up. Stop promoting those things. I would say you don't need to. Because at the very end of the story is something that I would say is, frankly, it's just not that sexy. It's simple, but it's just a basic financial product. It's the life insurance, the cash value grows based, tax deferred. You can pull it out tax free. The death benefit is tax. It's like a Roth IRA. Same thing with annuities. There's already a bunch of tax advantages to it. And it seems like we're downplaying those, even though the federal government, the old joke, I'm here from the government, I'm here to help. That's not true. They actually did. They want people to save for retirement via an annuity. They want death benefits and cash value life insurance to be tax free. They want to prepare for long-term care. They know the government's not going to be able to pay for it. So they give us these tax breaks, and then we kind of say, well, if you can't give me a deduction on the way in, I don't want to talk about it. So the most common question I get is small, closely held business owners, very successful, making 300 to 500, maybe up to $1 million a year, something along those lines, and they just simply don't want to pay taxes. And the advisors want to find some magic pill that does that for them. It's deductible on the way in, grows tax-free, and then you could take it out tax-free. If you could do that, that would be fantastic. No one's built that. But I hear all sorts of things from captive insurance programs and things like that. Sometimes they work, sometimes they don't. But they let the tax tail wag the dog, so to speak. Mm-hmm. I don't know if that helped or not, but that's the most common question I get.
Yeah, and I'll kind of add a little commentary to that, because the context of our recent workings together, is kind of that type of a case where we have a small business owner that has fought the fight, and now he's at the spot where the business is generating good revenue. He's got a good track history of revenue, and his profit is disproportionately going to Uncle Sam. And there are tools out there that allow us. You mentioned defined benefit type plans that allow a lot of money to be deferred in the future, so you're not paying tax on it now, and that's all well and good. The things that David was talking about there that kind of turn into abusive is when we're trying to always avoid the tax man. It's the rule of pig, right? Pigs get slaughtered, and but there are these type of tools out there that can really change the economics of a small business owner that thinks that there's no options out there.
With the right fact pattern, 100%. Some of those solutions absolutely can be beneficial. A business owner who makes a fair amount of money and has a small number of employees who are younger and don't make that much money. Like that fact pattern, I know where I'm going to head with that. I know where the solution is, at least up front. So yeah.
Yeah. And so to the listener out there, these are concepts that I was several years into the business, let alone my law practice, before I started realizing or being exposed to these tools that are out there. And our clients, the client I was working with just today, had no idea that these type of things could be done to change the math on their business and their personal tax picture. And I'm going to ask my fly on the wall to get back in here in just a second, who's a guy that, talks to lots of financial advisors in this world. And I bet you he's got a few things to say, because he's got a business as well. And these type of tools are pertinent to cases that are coming across your desk right now as a estate planning small business attorney, and the type of impact you can have on your clients' lives, let alone your own financial reward that comes from it, which we always do need to recognize that's part of the game, are tremendous for everybody. So Matt, how did my fly on the wall hear things today? Are there any questions and follow up? You always have such insightful, and I'm doing you a disservice by setting the expectations, but our listeners always know that you're going to have a question that they were thinking.
Well, first off, David said a couple of things there that I really want to highlight. The first one is just because you don't want to pay taxes doesn't mean that you don't still have to pay taxes, man. And I mean, I'm paraphrasing what he said there, and I love that. But what I really, really liked is the fact that really, no matter what your situation, there is a favorable solution that advanced planning in coordination with tax and legal can make a huge difference in your entrepreneurial lifestyle, especially when it comes to an exit, which gives me hope, right? I'm in a very, very complex strategy. I own part of a Canadian company. There's all sorts of craziness that's happening with that. And if my partner and I ever do sell, I'm leaning on people like you because I know that there are solutions in place that I need to put in place. More importantly, and this is another thing that I've heard Greg say this a lot. More importantly, I need to do it not like 24 hours before the deal's going down, right? So make sure that the advanced planning should be in advance, which I really liked that too. I also like the fact that, David, that you highlighted that there are people who are trying to do things that are really pushing the limits and or crossing lines with the law, which is why I think the Wealth Solutions Network is so incredibly important, because estate planning attorneys are in such a perfect position within the financial life of their clients to truly be able to help with a lot more oversight than just a normal financial services professional, or, not to be mean, somebody who's just trying to sell you cash value life insurance because it's the solution for everything. So
Thank you, Matt, for your feedback. And David, thank you for your time here today. Matt, you want to take us on home?
I do. Well, actually, so I'm assuming, Greg, that if anybody wants to get a hold of David, they should basically just reach out to you, or can they reach out to David directly?
I think they should be reaching out to me.
Perfect.
Don't need everybody going to David.
Well, no, and I think that that's a level of conversation that your expertise in between would be really fantastic. So listen, everybody, if you have not gone to joinwsn.com to go ahead and join the Wealth Solutions Network, well, I don't know what you're doing because you've been listening to a whole bunch of these podcasts. Just get off the pot and click that button and join the network. If you want to set up a call, there's a great way to do that. Just right on that Wealth Solutions Network page to go ahead and have a call with Greg to find out if this is the right solution for you. And if you know an estate planning attorney that does need this information and you think that they could implement this into their practice, please, please, please go ahead and share this show with them. So for Greg and for David, this is Matt Halloran, and we'll see you on the other side of the mic very soon.
Thank you for listening to the March to a Million podcast. Click the follow button to be notified when new episodes become available, and get in touch with our team by visiting our website at www.wealthsolutionsgroup.biz, or give us a call at 614-432-8065. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Wealth Solutions Network. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice from qualified financial service providers with any questions you may have.